Good morning from London, everyone, and welcome to today's FS Club webinar. And today we have as our guest Anne Rose, Managing Associate with Mishcon de Reya, who is one of the rising stars in the legal world surrounding blockchain, crypto assets, cryptocurrencies, and many other things. Anne is here today to talk about tech law advocates' blockchain work, and particularly some of the recent legal and regulatory guidance. You'll know me, I'm Michael Mainelli. I'm one of the directors of Yen, and it really is a privilege to be able to introduce these webinars, and I can do so only because our sponsors allow us to range widely and freely across technology, economics, and finance. And certainly today, touching on the immense world of the economy of crypto assets, the technology involved, and the finance in a rapidly changing sector, it's really good to get some grounded guidance on what does this really mean, though? Have we truly left the planet and gone into some new crypto space? No, the law still applies. I won't regale you with tales about the rise of Bitcoin recently or anything else like that, because we've got our expert here. But just a reminder of our format. I will be getting out of the way as quickly as I can so that you can hear directly from Anne and speak with her. She'll be speaking for approximately 20 minutes. And then we'll move into Q&A. A few items for you. The slides will be posted and probably are posted if you have a quick look in the chat room. The recording will be up in approximately 48 working hours, i.e. Probably Monday morning. And a final point here is please do use the GoToWebinar question and answer facility down in that chat space to send me questions that I can feed in to the conversation with Anne, but also comments, observations, whatever's on your mind. But please do use that facility because I'm here with you and I won't be getting your emails or your text or your signal messages or anything. So please do use that. All of your questions, comments, and observations will be sent to Anne with your email attached. So if you just want to contact her, ask her a detailed question offline, just send it to her and I'll make sure that she gets all of that from you. So really, I guess with no further ado, Anne, very much the floor is yours.
Fantastic. Thank you so much, Michael, for your lovely introduction. So everyone, yes, I am here to talk today about blockchain, the law, and in particular, tech law and advocates blockchain legal and regulatory guidance, which we published in September last year. Next slide, please, Michael. Next one. I might have a delay.
They take a little bit of
Brilliant. So just a few points here, which I'm going to cover today. Just a very brief recap as to what blockchain is, how it can be applied, talking about the legal guidance, so why it's needed, what does the legal report cover, looking a little bit at some of the statements that have been produced in the past as well. So we're looking at the legal statements of assets held or represented on a distributed ledger. What's the problem? How's the problem currently being addressed in law? Looking at smart contracts, a few other legal and regulatory updates, and then I want to follow up as well with some next steps and get your thoughts here from the audience. So what is blockchain? Next slide, please. So blockchain is a ledger which can be used to identify ownership and audit transactions. So the word blockchain actually denotes a specific subset of the broader class of distributed ledger technologies, most commonly associated with cryptocurrencies such as Bitcoin, which you're probably all familiar with. Blockchains take their name from the way in which their data is structured. So blockchains take a number of records and put them into blocks, which are then linked together in a chronological chain using a cryptographic signature. So that is very simple terms. The next slide. Thank you very much. So this is where I want to get to the crux of as well. Obviously, why? If blockchain is just a ledger, why do we even care? So traditionally, our ledgers look like this. The earliest ledgers are around 4000 BC in Mesopotamia, and these recorded the ownership of crops and storage, and were kept in clay scripts or carved into stone. And if I wanted to check how much grain I owned in the scenario, I go to the script or the stone and I check. It works in many instances. Think about, pre-COVID times, your honesty fridge in the office. Not particularly robust. So if I disagree with the script or the stone or what someone's written down in the honesty fridge, what then? So the problem has actually meant an increase in the decentralized model for networks. So we, the dots on the outside, delegate our trust every day to these core dots, the intermediaries, and they connect us with the wider systems. It could be a bank, for example, it could be Facebook, and this is better, but it has its downside. So the bank or Facebook in this example still hold the key to the truth at any point in time. And if they fail, they go rogue, we're in a bit of trouble, and we have limited recourse. So we move to the distributed network model. It's difficult to maintain, but with no single points of failure and theoretically infinite scalability. Crucially, this model eliminates the need for a trusted intermediary. The network polices itself by maintaining a universally held view of the world from time to time. So in short, very, very brief, that is blockchain. It's a new form of bookkeeping. It might sound pretty dull, but it's actually massive. The exchanges of value on which society is founded requires us to trust each other's claims or our intermediaries' claims on our behalf. Also what we owe, what we're owed, and what we owe. So by utilizing a distributed network, a blockchain gives us, for the first time, a way for one internet user to transfer a unique piece of digital property to another internet user, such that the transfer is guaranteed to be safe, secure, and everyone knows that the transfer has taken place. And nobody can challenge the legitimacy of the transfer. And the consequences of that breakthrough, I think, are very hard to overstate. So as you can see on the slide, this looks at a few examples of how blockchain might be applied. You know, we've got here identity fraud as an example, supply chain management, smart contracts, healthcare. You can read the slide as well to have a little bit more detail as to each of those specific sections. Then blockchain is being applied in a wide variety of sectors and also all over the world. So in the next slide, you can see legislation and regulation for emerging technologies globally. So I've set out a few examples here on the next slide, which are by governments themselves. So in the UK, you've got the Digital Pound Initiative. The Trusted Shared Ledger enables greater automation and closer monetary policy control by reference to real-time changes, which is very exciting. So as you see, it's increasing use, not only in various sectors, but also all over the world. And so I think a few years ago, I often found that when I was at the firm and a DLT query came in, I'd be asked for assistance. And it could be in an area completely unrelated to my practice, such as fraud. And I wanted to be able to produce guidance to help legal practitioners working in the space to not only feel comfortable with advising clients and applying their knowledge to this new technology. So I started by writing an academic article on blockchain and its interaction with GDPR at the beginning of 2019. And I realized there must be other areas of further guidance that's required from regulatory authorities or other bodies. So as you see on the next slide, on the basis of this idea, I founded a group called Tech London Advocates Blockchain Legal and Regulatory Group in 2019. And which through hosting various seminars and meetings with industry experts, and creating publications like this report, which we published in September, it aims to address some of these issues. So I contacted the Law Society and lawyers from a number of different firms, and it grew from there, which was really exciting. We now have over 250 people involved in the group, and we were lucky enough to have some excellent speakers and experts feed in from the very beginning, including you, Michael, which was absolutely fantastic, and it was great to really be able to kickstart off some of our sessions with such a great speaker. So the report covers a wide number of areas. So as you can see from the slide, we've got the commercial application of blockchain technology. So a lawyer, Johnny Emmanuel from Bird & Bird, he sets out a use case for blockchain technology to track and trace goods in the retail sector. So the report looks at how blockchain might be set up, the advantages and disadvantages of the use of private and public blockchains. And he also talks as well, Michael, about one of your fantastic initiatives, Code ID, which I'd love to hear a little bit more about. It sounds really fantastic. Then there's also, we've got a section here on smart contracts and data governance. So the report offers an in-depth analysis of the advantages and disadvantages of smart legal contracts, the role of data and data governance in smart contracts, and key considerations relating to data governance in the context of digitization projects. And we also looked at some real-world examples of successful digitization projects and the impact of DAOs in the legal profession. We also look at blockchain consortia. So Sue Baker McKenzie, there's an excellent section here, and it can be hugely effective in promoting, developing, enhancing, and integrating blockchain technology. However, serious thought obviously needs to be given to the way a consortium is set up, and the report produced provides guidance on that kind of effective governance and project management that might be required to ensure the longevity of a consortium. And it also provides guidance on the common legal frameworks of consortia, the legal risks and issues to be considered when setting up or joining a consortium. Then there's a section as well on data protection and security, which I wrote with a colleague. We also had Michelle Fink feed in, which was fantastic, and Addy as well, some of you may know from Applies Blockchain. And so in an already complex legislative area, the use and continuing development of blockchain gives rise to a number of specific tensions with GDPR. And the report looks closely at some of these tensions, including those in relation to pseudonymization and anonymization and the definition of personal data. The report also looks at zero-knowledge proofs, providing an explanation of how these work to increase data privacy and demonstrating their centrality to the development of DLT technologies. Then we have intellectual property. It looks at the context of blockchain in the current legal framework with reference specifically to UK and EU case law. So while DLT has the potential to revolutionize the way some IP rights are recorded, protected, and ultimately enforced, the report also highlights the implications that the features of DLT technologies on the potential infringement of these rights, and looks at whether certain DLT applications, such as cryptoassets and smart contracts, attract any rights at all. And then we go on to dispute resolution, which I will touch a little bit further on as well a bit later. We look here at the use of DLT technologies, which raises new legal, procedural, and practical questions about how disputes arise and how they are best resolved. So as well as looking at the impact generally of technology and dispute resolution mechanisms currently available, as well as fundamentally questions to be considered by practitioners in relation to jurisdictions, applicable law, and money laundering. Then we did two other sections. One was on the regulation of cryptoassets, and it sets out a detailed overview of the regulatory treatment of cryptoassets, both in the UK and globally, including, importantly, the FCA's treatment of security tokens, e-money tokens, and unregulated tokens. And this was a fantastic effort, which was spearheaded as well by Alan Overy and Clifford Chart. And then we also have the tax section here, which has the report acknowledges the potential for widespread disruption in this area of law. It sets out the potential of DLT technologies to transform the tax system in the UK and provides much needed guidance on the taxation of cryptoassets, the impact of blockchain, the in-house function, and the impact of blockchain on tax authorities. And this obviously needs to be updated later in due course as well with the newly released cryptoasset manual. So as we weren't able, unfortunately, to do the launch of the publication in person, so we had to do it on Zoom. But it was great to have everyone join, and as Jeffrey noted on the panel, this guidance really does represent a gear change, and functional familiarity needs to bring an end to the theory and to start working effectively with the practice. And I really believe that every lawyer in every field will need to be familiar with blockchain, smart contracts, and cryptoassets, because their clients will be dealing with them day in and day out in every imaginable context. So previously, as you can see on the slide, there had already, before this, there was the launch of the statement on cryptoassets and smart contracts, which many of you will be familiar with. And this provided much legal certainty in global financial industry and beyond. And it was released in November 2019. And it primarily focused, as I said, on cryptoassets and smart contracts. So I'd love to run a poll now and see how many of you may have read this and what you think were the 5 key characteristics used to describe a cryptoasset in a legal statement.
So I've just launched that poll. I must say this is a slightly more complex poll than usual, Anne. Our audience frequently answer within 8 or 9 seconds over half the audience, but we're finally coming in Even then, FS Club people are swift off their feet, and over 20% have made a decision now. I myself found this a bit challenging and had to read it twice.
Excellent.
So very
good.
Good.
For the morning.
Over half the audience have successfully navigated the question. I'll hold it over just another second or two longer. We seem to be converging on an answer. Good. And I'm just about to close now with 2/3, yeah, 3/4. Here we go. Okay, and I'll just share the results now. And basically 60% chose B. So put them out of their misery. Which one was it?
It would be.
There we go. Well, you're dealing with a pretty swift audience out here, and they seem to have got the point. Yeah, that's very good.
It's great to see.
There we go.
Yes, so as you rightly pointed out, great. Yeah, I haven't seen that feature before. It's fantastic. So really great to see how engaged everyone is, and it's cool. And the legal statement describes the features of crypto assets as novel, and as you rightly pointed out, has the 5 key characteristics. So intangibility, cryptographic authentication, use of a distributed transaction ledger, decentralization, and rule by consensus. And these characteristics do not preclude crypto assets being treated as property. Indeed, the legal statement notes that one of the fundamental aspects of property is ownership, and that crypto assets are capable of being owned. So what does this mean if a crypto asset can be owned? Like, what category does it fall into here? So the legal statement notes that a crypto asset is not a thing in possession. It's like a tangible property that can be the subject of physical possession and so physical control, but maybe a thing in action, where that is taken to refer to any property that is not a thing in possession. However, the statement concludes that a crypto asset may be best treated as being another third kind of property, which is neither a thing in action nor a thing in possession, as you see on the next slide. So there's a catch-all to refer to any property which is not a thing in possession. And this conclusion will affect the treatment of crypto assets at a number of levels, including on insolvency and succession, and in cases of fraud, theft, or breach of trust. Some of you on the call may be familiar with some of the recent cases that have been coming out. And in December 2020, it was great to see there was the Ion Science Limited case. And this was the first case before the commercial court dealing with ICO fraud. And it was the first case where the court has considered the location of crypto assets for the purpose of the applicable law, and the first time the court was granted permission to serve a freestanding banker's trust order out of jurisdiction against cryptocurrency exchanges. And one of the interesting things I found as well as in this case is, without going into too much detail of the grounds and looking at whether how they defined like crypto assets were changed as property in this case, one thing that was interesting to me is that it referred to this statement, and the statement has been so well received, and it's also been referred to a whole load of other statements, including Robertson and Persons and the New Zealand case as well in Roscoe and Cryptopia. So that was, I think, it's quite exciting, some of the work that the UKGAP is doing. So next I'm going to go on to smart contracts. So the other confirmation legal statement is, which many of you will probably think, of course, is that smart contracts can be or be part of binding legal contracts. And so, just a quick recap for some of you who may not know what a smart contract is. The number of people who tell you that they are game-changing is actually excruciating. They are probably one of the most uninteresting things ever. They're not smart, they're not contracts. They are basically slightly more nuanced if Excel functions, if X, then Y. Smart contracts are only valuable because of the data integrity on the blockchain. So think about it. If we know the underlying data is correct, what level of automation does this enable? It's huge. I mean, escrow arrangements are the obvious, boring example. If money lands in an account, then transfer to widget, for example, no intermediary, no associated cost in time or money. The examples can get far more exciting. You know, one of the FDA sandbox companies previously was building a blockchain-based solution for the travel industry, insurance industry. So, you know, every time, you know, if you ever try and get assured payout for a late flight, obviously not at the moment, but in previous times when you could fly, it was always such a nightmare. You need to prove who you are and that you have a policy, prove that you were supposed to be on the relevant plane, prove that the plane was delayed, hope that the plane was delayed by an insurable event, and determine whether you could have mitigated your loss by getting another flight, etc., etc. And, you know, Acerus, I think it was Acerus, if I pronounce that correctly. Sorry if it's incorrect. It was one of the FCA sandbox companies, and it was building a solution whereby all of their data is based on the blockchain and therefore has sufficient data integrity to allay any consumer and insurer's fears of foul play. And by the time you touch down your destination, you have a push notification on your phone asking you how you want to receive your payout. Pounds, dollars, Bitcoin, Ethereum. It is pretty cool. So people say that code is law, but, you know, a code isn't enforced like law, it's executed. And, you know, that is also making sure that when lawyers are talking to programmers that we're all using, when we're saying the word executed, we're sometimes referring to it, they're using the same words to refer to different things. And this self-execution coupled with the improved data integrity of the underlying blockchain significantly reduces the potential for dispute. Finally, I'm probably reassuring to most people here, we always recommend for a legal wrapper to govern the relationship between the blockchain solution and the traditional legal process. It's maybe some sort of click-through terms and conditions incorporated in, for example, an app's user interface. And that's it really for smart contracts. So in the legal statement, it was really looking at enforceability. So the first question here is, are smart contracts capable of being enforced? Do they constitute binding legal contracts? And the answer is yes. The legal statement concludes that smart contract is capable of satisfying the basic requirements of English law legal contracts. You know, those requirements are that two or more parties reach an agreement, parties intend to create a legal relationship by doing so, and have each given something of benefit. So whether the requirements are in fact met in any given case will depend on the parties' words and conduct, just as it does with any other contract under English law. And then the next thing it looks at is, can parties' contractual obligations be defined by reference to computer code? Well, yes, contractual obligations may be defined by computer code. I mean, however, the code may also merely implement an agreement whose meaning is to be found elsewhere, in which case the code is unimportant from the perspective of defining the agreement. But either way, the legal statement concludes that smart contract can be identified, interpreted, and enforced using ordinary and well-established legal principles. And finally, how does English law address issues regarding parties' anonymity or pseudonymity? Well, it suggests that English law can deal with bilateral smart contracts and decentralized autonomous organizations, where the party that deploys the code to set up the DAO has no intention to participate in it or enter into a legally binding agreement with it. So by analogy, the legal statement draws on the well-established concept of, for instance, an unincorporated association, which has no legal statement, no legal status, but all the members, for example, because of their membership, are bound by these rules. So that's the legal statement. So just a few other legal and regulatory updates have been coming out over the past few years. Very briefly, we've got here some on security law and derivatives on the next page. Following a recent consultation, the FCA prohibits the sale to retail clients of investment products with reference to cryptoassets. This is due to concerns mainly around consumer protection and market integrity. It applies to derivatives and exchange-traded notes. And the FCA, during the consultation, suggested a definition of unregulated transferable cryptoassets to cover these products, which are found in the FCA's handbooks. And the changes came into force this year on the 6th of January, 2021, the Epiphany. And the FCA also consulted on the taxonomy of cryptoassets. And the most important distinction is whether tokens fall inside or out of regulation. And e-money tokens will also be separated from the utility token and security tokens category, creating a specific e-money token category and unregulated category, which includes utility tokens. And then we've also had HMRC's latest guidance, which confirms it does not consider any current crypto assets to be money or currency, and it does not consider tax to be payable on receipt of hard forked crypto assets. Contrast this with the Internal Revenue Service in the US, and we see a stark difference in that. So the fair market value of the new crypto assets received following a hard fork will be taxed as gross income in the hands of the taxpayer, and the new crypto assets will have a fair market value based cost for the purposes of calculating a gain on disposal. And I think it's only last week as well, or maybe 2 weeks ago now, the HMRC has also released this new crypto assets manual. And at the moment as well, some of you may be familiar with things that are going on with the Law Commission, which is very exciting. They have got 2 calls for evidence and consultations that they are investigating. I had the wonderful pleasure of being able to interview last week Sarah Green, the Law Commissioner, who is looking into these specific sectors. And the first one is around smart contracts. And the Law Commission seeking views about and evidence of the ways in which smart contracts are being used, the extent to which the existing law can accommodate them. And the second is actually on digitized assets, which is really very, very exciting. And they're considering the issue of possession, particularly with regards to documents of title, documentary intangibles, and negotiable instruments. So that is very exciting. We'll wait to see what the outcome of that is. So just in terms of next steps, as some of you may have seen, if you have read the report, which a copy of this is here, it's also available on the Law Society website. But if you are not part of Tech London Advocates Legal Regulatory Group and you want to be, please do message me. I just want to note that not everything is covered in there. So you saw earlier, I only mentioned a few sections. So for instance, we don't even have a section on competition law, which is one we're definitely going to have in the new publication. And it would be great to have others involved in different sectors to help add to this report and expand some of the areas that are covered. And as Jackie noted in that panel talk that we did in September, you know, the hard work is yet to come. It is important to keep it up to date. It's important for us as well to keep advocating, to make changes where they are needed, and to produce guidance to give people confidence in the space. So in terms of next steps, trying to get input from key authorities. You know, the law is not defunct. We need further guidance from those who have authority to enable blockchain to flourish. I think this can only accelerate, especially in the current circumstances. You know, the disruption caused by the COVID-19 pandemic has forced governments and businesses to reevaluate their service and business models more fundamentally than ever before. Organizations that have historically been slow to embrace change, lawyers included, are now, by necessity, making great strides to innovate and are looking to emerging technologies such as blockchain to help them do so. So as we can see here, I've kind of got a few issues here. So corporates and government entities should increase their key stakeholders' awareness and understanding of DLT, including blockchain. Where the potential value of DLT is recognised, to have a clearly articulated strategy and roadmap should be developed and implemented. Ambitious entities think about the design and development of their own applications, both to improve their own internal processes and to develop potentially an alternative revenue stream or boost market influence, and care needs to be taken to ensure robust resistance to fraud. And then I have one last poll, which I would love to run. Some of you may be aware that the UK Jurisdictional Task Force is soon to publish, very excitingly, probably around FinTech Week in the 19th of April, it's digital dispute resolution rules, which we have done extensive public and private consultation with lawyers, technical experts, financial services, and commercial parties. And the intention is for these to be used for and incorporated into on-chain digital relationships and smart contracts. And I've been working with the committee on drafting these rules, and it's been great as well seeing everybody's feedback to these rules. And I just wanted to get a gauge from the audience. Yeah, does anyone actually think there is a need for or advantage in having a new arbitral process for resolving disputes arising out of novel digital technologies? Fantastic. Great. It's so good to hear. Wonderful. I was hoping that would be the answer. Oh, I can't hear you, Michael.
So, sorry, there. It was the audience moved very rapidly. My apologies. Yeah, they came in under 10 seconds there. And amazingly agreeing with you. I'm going to put forward a few quick ones, if I might. Here's something slightly tongue-in-cheek from Philip Leone. He's asking, which cryptos would Mishcon accept for settlement of your fees?
That is actually a very interesting question, and something that we are exploring actually at the moment. So afraid it's not a definitive answer.
That's fine. Bob McDowell's sort of curious, what case law exists, if any, on governing blockchain?
So there's been lots of different cases which have been coming out in the recent courts, some of which aren't actually reported. I mentioned one earlier, which was the Ion Science and Persons Unknown and others. It is actually unreported, but a copy of the report has been provided, and I'm not sure how widely available it is, but it was published on 21st December 2020, and it was in the commercial courts. And as I was saying before, it's specifically looking at ICO fraud, and it was a very interesting case. I mean, in short, you know, you've got Ion Science, and actually, I don't know how interested people are if we're going to go into into all the details. Maybe that's something I'll follow up with you later, and I can actually provide you with a summary of the case, why it's significant, the interesting parts in the interim injunction, and the bank transfer order. So it is very interesting. There's been other cases as well, actually looking at cryptoassets and property itself. So I mentioned Robertson and Persons Unknown case, again unreported. And there've been a few as well coming out in New Zealand, in Singapore, and you know, the UK courts as well, looking at the Commonwealth for some of the influence of those decisions. And there's also, if anyone is interested, actually there is a fantastic book on cryptocurrencies, public and private law, edited by David Fox and Sarah Green, which is actually often referred to in many unreported cases. It's very good.
Johnny Fry, in a related question, just an addendum really, is there case law on smart contracts that they're legally enforceable?
Not that I have seen yet, but it doesn't mean that there aren't any out there, but that's an interesting one.
Okay. You spoke about a traditional legal wrapper governing a blockchain's solutions relationship with the traditional legal process. Bob McDowell's curious, could you just give a quick outline of some of the key constituents of such a wrapper?
Yeah, absolutely. I mean, some of you as well may have been following the Beeple, the art work which sold for around $69 million in Christie's, the auction. And so whilst it's looking at the NFTs, the non-fungible tokens, and whilst the transaction took place on-chain, all the governing terms for the auction and the terms of the sale are all actually off-chain. It's actually a traditional legal agreement which has been signed and executed by both parties, setting out the key terms, the money that was transferred over, the terms that govern the sale, the governing law, and so forth. So it's interesting as there are very few, I would say, big key transactions happening at the moment which doesn't have some sort of off-chain legal either FAQs or agreement as well that you can actually see. So as well, even if you are buying CryptoKitties as well, you can see the terms of the license on the website and what govern it, and so you're actually easily able to access it. So at the end of the day as well, if something does go wrong, you do have the course to know what law governs it and whether it should be governed by the courts or not.
And related to that, Edward Nickel was wondering if you could just expand a teensy bit. You know, he's used to jurisdictional clauses in contract, but how is this replicated in blockchain or smart contracts?
In terms of, are you saying, I mean, obviously when you put something off chain, you can specify whatever law you want to do. So as well, I mean, and as well, that's one of the things as well with the online dispute resolution rules which we have put together. That is governed by English law. You know, if you don't reference the law specifically that is governing the agreements that you are putting in place or the transactions that you're working on, it can really lead to confusion later down the line if something does go wrong. Or even if something goes right. You want to be able to enforce your rights.
Xiufu Hui points out quite rightly that this new digital process is absolutely fundamentally related to the internet working. What sort of clauses do you put in about what happens if all the digital outs to these assets if there's a failure of the web?
Sorry, can you repeat the question, please?
Yeah, sure. Xiu Fun Hui is curious about the dependency of all of this crypto asset space on a functioning internet. What sort of clauses are related to failure of the internet or the web?
Yeah, that's interesting. I mean, so this is also a very interesting one as well when we're looking at some of the recent issues that come out with NFTs. People have suddenly been buying these NFTs and they're like, they look and their URL link's gone and they can't see their NFTs anymore. And actually just thinking about as well, backups, thinking about IFPS, thinking about ensuring that you have proper recourse there. In terms of the protections you can draft this to ensure that it is you're properly protected. And if you then did decide as well to use a form of, say, these digital dispute resolution rules to actually enforce your rights on chain, we have actually created a set of rules which will be published and is governed by arbitration. And SCL, the Society of Computer Law, would be the tribunal for that. And you can actually get a version of the rules when it's published, and you can actually incorporate that into your system to provide you with better protection.
Last week, a week and a day ago, Zien issued a $100 trillion NFT of a turbot, our non-fungible fishy token. So the audience is clearly very interested in NFTs today. Hugh Purser is interested on the IP relationships, but I'm going to read out a slightly lengthy comment/question from Timothy Coleman, which I think is extremely good. So in regards to NFTs on blockchains, there's a lot of talk about what rights one gets when buying the NFT itself. In the arts world in the States, unless explicitly specified, people can't reproduce a painting, for example, onto a t-shirt without also having bought the IP. Does this separation between IP and the thing itself occur in most jurisdictions? And do you know if there's a definitive list anywhere of what applies within various jurisdictions? You may find that something you'd want to take partially offline, but just on the concept of the IP separation.
Very interesting. I've actually as well, there is, if other people as well are interested, there is an article actually on the Mishcon website, which I have written specifically looking at FT and NFTs and IP. For some of you who may not know, just on the call very quickly, an NFT is a unique, non-divisible token. It's often linked to an object, so it could be a collectible, it could be digital art, it could be an in-game asset, and it uses blockchain technology to record ownership and validate authenticity. So fungible tokens, which you'll be familiar with, like blockchain, are not unique and therefore do not qualify as an NFT. There are various NFT token standards. You've got Ethereum's ERC-71, and you've got some new standards, the ERC-1155, a few others, and so forth. And so, what's important to know, as the listener rightly picks up, is that to note that the NFT is not the digital asset itself. It's an electronic record. It is metadata that's representing ownership of the asset. So when an NFT is bought, the purchaser holds the right to claim ownership of the NFT. Think of it like a receipt of a proof of purchase, for instance. But absent terms stating otherwise, ownership of an NFT does not entitle that purchaser to ownership of the underlying asset. And it is that, I think there's been a lot of confusion around the press at the moment on this. And it is thinking about that and thinking about if there is copyright in an NFT, think about what actual rights you have when you purchase an NFT, and ensuring that you understand that before you make that transaction. And that is why as well I think it is important to have this kind of a legal wrapper around it to actually set out the terms that govern an NFT license. You really, really understand, especially as well as a consumer, what you are buying and what rights you have later on. And I would love to speak with your listener later offline and go into much more.
We'll get that email over to you with all the others. Jeremy Light, how does the law deal with an asset that is represented on two or more separate blockchains? How is ownership proved?
Okay, can you give an example?
Well, I can certainly see, we'll take the NFT stuff. I've put it onto, say, an Ethereum system, and then I've put it on a Dogecoin. Who's going to know?
Yeah, and I think this is an interesting point, which also is a bit of an issue at the moment as well, which people are starting to discover when they are getting into the realm of NFTs and actually thinking about all the steps a little bit further and to ensure you really understand what you're buying. Ensuring as well, thinking about the marketplace that you're using. Is it a reliable marketplace? What are the terms as well as the marketplace? There's so many out there, depending on what you're buying, whether you're using OpenSea, Rarible, so forth, and all of them. Some are more reliable than others, and as well, you you want to ensure as well what DD is done on people who are putting up their digital art. For instance, if you're doing a pure NFT where you're talking about an online digital asset, and it hasn't been just copied, Picasso work from elsewhere, it is. I think there's so much out there, and it's very hard to ensure that people are really savvy as to what they're buying and their rights.
We have Lord Holmes coming on, I believe, in the next few weeks, and he's going to be talking about what should a digital services bill contain, a la a financial services bill. And I know that he's looking at crypto assets and cryptocurrencies. Bob McDowell's kind of curious, has the development of blockchain reached such a level that legislative aspects should be codified as statute law?
Interesting. I don't think so for the moment.
And why is that?
Question.
Okay. Got an interesting one as well here, a question really from Johnny Fry. Again, how soon do you think it will be before we see a sterling central bank digital currency launched? And won't that mean that the UK will have to change the law so to enable the issuance of digital securities, as we've seen in Switzerland and Luxembourg?
Yeah, very interesting. I mean, it could potentially happen in the next few years, but I'm not close enough, I would say, in that space to have a really good grasp as to the length of time. But I certainly think there is change on the horizon. And as well, going back as well to the governance of blockchain itself, I mean, we are getting more and more regulations coming out at the moment, and it is, if you think about it as well, in the UK, internet law hasn't really changed since 2003, and so much has happened. And, we're having a lot of things come out at the moment in terms of looking at platform liability, thinking about online harms, things like changes as well in consumer legislation. And what will also be interesting to see as well is, as a result of Brexit, is how much we start to as well stop harmonising with the EU over the next few years, and what sort of route that we take, and whether we decide to go down the same path. We've met some of you who are on the call who may be lawyers and will be familiar as well with all the changes that have been have come out in the EU in this space, and there's a lot going on at the moment. I think it's a very, very exciting time to be working in this space, especially as a lawyer, I would say, because there's just so much change going on, I think lots of changes to go ahead.
It's been a very dynamic chat room, but we're running out of time. So I'm just going to take one last comment for you to come back on. And in fact, on a personal note, I think it was about 6 years ago, I assembled a group of arbitrators and mediators and said to them that this was an ideal area for arbitration and mediation. And you've been talking about a new arbitral process, so I'm quite keen on it. And so the question isn't quite in line with mine. And this is from Dagmar Peterson. His perception is that arbitration is slow and costly. Why are you choosing this as a default?
So it's very interesting. So these rules are intended to facilitate the rapid, cost-effective resolution of disputes which arise in the context of digital assets, smart contracts, blockchain, other technologies, to foster confidence in their use. The rules allow parties to resolve disputes in arbitration by an arbiter rather than by a judge in court. And unlike other sets of arbitration rules, the key objective is to provide maximum flexibility in the procedure. So it can then be tailored to the distinctive features of that technology, and to ensure disputes to be resolved quickly by arbitrators with appropriate technical expertise. And they are deliberately short. I mean, if you saw them in the public consultation, they are only a few pages. We're talking 3-4 pages. And they provide for a speedy process which can be extended if required to fit the needs of the particular dispute and encourage the use of technology in the process. And they need to be read against the background of the Arbitration Act 1996, which some of you may be familiar with, which amongst other things set out sensible defaults for circumstances not expressly dealt with by the rules themselves. But this flexibility and the length of the rules, I think, will really, really help to ensure that these results disputes are resolved very quickly.
And your mastery of the subject is impressive, and there are many, many more questions down here I wish to go on, and people are interested in areas like fraud, the scale and length of contracts and legal wrappers. They're very interested in some of the technical evolution, which I didn't want to throw at you, and some doubting the competence of our judiciary or our peers to judge or even mediate on some of these things. So there's a lot here. All that will be sent to you. If you don't mind, I've got 3 quick rounds of thanks to give. Firstly, to our sponsors. You are very kind and generous, and you do allow us to cover all sorts of subjects, and I hope that you, like I, found today's session worthwhile. I'd like to thank you, the audience, particularly vibrant today, and she really threw you a humdinger at the start there, didn't Anne? And you responded very well and got the answer right, so well done to the audience. We have a number of forthcoming events, and I won't go through them. As ever, go and check out the website. But I might ring a particular bell for tomorrow morning at 11 or 12 o'clock in Paris, when we're going to have a fascinating look from a dear friend of mine, Emmanuel Antman, at Financière de Courcelles, and he's going to be looking at the European M&A landscape with some surprising insights, very surprising insights on how COVID-19 has not necessarily been a disaster at all. So a lot coming up. But of course, the real thanks today is only for you, Andy. It was so kind of you to come up here on the program. And we've been absolutely delighted to have you, and most impressed with your, not just your knowledge and your technical wizardry and everything else, but also the immense progress you've made in just a very few years with TLA. It's what, 3 years, I think. So very well done. And I'm unfortunately unable to give you a technical applause. So I have here my Korean karmic clapper. We'll have to substitute the audience's great floodgates of applause, and we hope to have you back on and learn how things have progressed, perhaps in a few months. Thank you.
That's fantastic. Thank you so much for having me. Thank you, Michael.